And Wesley asks, do you think the mistrial not happening is in favor of YNW Melly? And how do you think his mannerisms in court will affect the jury's decision?
I'll take the last one first. And by the way, great questions. His mannerisms are not helping him in the courtroom. You just don't need the jurors to feel that those weird things he's doing are disrespectful to the court, because they're going to make an analogy. And maybe as a prosecutor, I want to sum up, if this is the way he takes it as a joke or whatever here, can you imagine what he's capable of doing outside of the courtroom? So I'll just leave that aside. As a defense lawyer, you just don't need that. With respect to the mistrial motion, great question. There's a lot of nuance here. Let's get to it. On the motion for a mistrial, what I had imagined the defense would have done, and Brian can see if he can confirm, and each state's a little bit different, is that the judge were to have granted it, the defense would have then indicated that they want to have the case dismissed for double jeopardy grounds. They would have argued that this mistrial was done because of purposeful, outrageous conduct by prosecutors, and that he should not be convicted or brought to trial a second time. Now, that's a really hard standard in most instances, but what the defense attorney clearly wants to do is create a record for appeal, and if the judge denies all these things, an appellate court can revisit it. But Anjanette, here is the tactical issue here. When you have a really good case and your case is going well, a lot of times you make these motions because you have to preserve the record, hoping the judge denies the motion, because if the judge were to say mistrial, but I'm not granting double jeopardy, so we go back to square one, the defense can't guarantee on the second act or the second play that the testimony is going to be as good, because they've already let their cards out to a certain extent. So a lot of times you want to win the battle by losing, or win the war by losing that battle. So it's a really sophisticated and nuanced thing here, but the judge actually did them a favor. The judges often say, you know what, I'm not granting a mistrial. Now you prosecutors have created an appellate issue in this case. Now I'm going to give a curative instruction to this jury to say what you did was wrong and that they should disregard it. And then the defense lawyers can say, whew, wow, now we don't have to have another trial from the beginning when our trial's going in so well right now.
Good insight from you, Bob Bianchi. I'm going to send this next question to you, Terri Austin. It's from Slap Shoddy from TikTok. What if Melly gets the death penalty and later on we find out it wasn't him?
Well, that's a good question. I mean, that's part of the issue many people have with the death penalty. There is no room for any sort of mistake. And there is a distinct possibility that if convicted, he could get the death penalty, because we know that the Governor DeSantis just signed a new law that says it doesn't have to be unanimous 12-0. It can be 8-4. And so it is a bigger possibility that that death sentence could be issued here. So if it's the wrong answer, and ultimately some of the other people that the defense pointed to who said might have been suspects in this case, but that the prosecution didn't go after them, if we find out later that someone else did it, or perhaps that, you know, Henry did it and Melly didn't do it, whatever the scenario is, if you find something out later, it is too late if in fact that death sentence has been issued and executed. Now, I will say that it does take years, because oftentimes there are appeals, as there should be, because it's a very final sentence. So hopefully, you know, if it gets to that point, it's the right conclusion, but that is in fact a very serious problem with the death penalty. You have to be absolutely correct.
Yeah, definitely. And, you know, a lot of people have a lot of questions about that lower threshold now for that law that Governor DeSantis just signed back in April. So this is just a recent thing that's happened. We'll send this question to you, Brian Buckmeyer. Horatio27 from TikTok asks, do you think the prosecutor will bring up prior bad acts, such as the shooting that happened?
So there should have been a ruling on it already as to whether or not it came in. The only other thing the prosecutor could do is try to question a witness in a way that opens the door. Or maybe if the defense puts on someone on the stand, this might actually be a reason why YNW Melly doesn't testify. Not necessarily because of anything that happened in this case or this incident, but because of prior bad acts. If he goes up there and says, I never touched the gun, I've never touched a gun in my life, then they get to attack that second half of it and say, hey, here are other cases, here are other videos, here are other photos of you showing the gun, and that prejudice could come in based on his own words. So do I think the prior bad acts will come in? At this point, I think if there's a ruling on it, no. However, testimony in the future, whether it be YNW Melly himself or other witnesses, could potentially open the door to it.
Let's go to our next question for Bob Bianchi. This is from @LegendDad2013 from Twitter. Why are they charging Melly with 2 first-degree murders when the other person in the car, Bortland, could have pulled the trigger?
Well, that kind of gets back to what Terry was talking about before. Listen, having tried death penalty cases, the #1 rule is you have to be absolutely convinced at who the person is that shot the individual. You can't have any hesitation about that. There could be no other explanation. So you also have to have aggravating factors in a case in order to get the death penalty. In this particular case, I think the aggravating factors against Melly are very weak to begin with, and they're certainly going to be weaker to the co-defendants or even aiders or abettors with regard to whether those aggravating factors exist sufficient enough to justify the imposition of the death penalty. So a shooter you get, the people that may have been surrounding them don't implicate the same aggravating factors as the shooter. So this is why, if there is any dispute in a prosecutor's mind as who the person was that potentially killed the person, it should not be a death penalty case. And if you are not surely convinced that you can prove beyond a reasonable doubt to each and every individual juror, each aggravating factor, at least one aggravating factor that justifies the death penalty beyond a reasonable doubt, then you should not be imposing it. We have a lower standard now with the DeSantis rule, if you will, but as a prosecutor that's tried death penalty cases for the life of me, I don't even understand why this is a death penalty case to begin with. I'm not suggesting that what happened is right, but you have to make a decision as to whether the aggravating factors in the case, for example, vulnerability of individuals, young people, old people, was it done, in the commission of a felony is certainly one of them. Was it done as part of terrorism? There's a number of aggravating factors. Are they sufficient enough to go in that direction where you're asking the jury to give the ultimate penalty, and especially in a case where the defense seems to be showing to a jury, he may not have even been the shooter. It's not a good death penalty case.
Well, the state says he was the shooter because they have this surveillance video of him getting into the back passenger or back driver's side seat. And so they're saying that these, bullets were fired from there. They're stippling on the victims, meaning at close range that these happened. There's another question, Terry, I'm going to send to you from Georgia Peach, I think, GA Peach 198 from Twitter. And this is kind of tough because we heard this testimony last week, but I think it's kind of, confusing to people. Can you explain the trajectory of the bullets in reference to the angle of the bullets in the car?
Well, it's interesting because during the opening for the prosecution, she actually did state, listen, don't forget your science that you learned when you were in school. And she admitted it's not going to be foolproof, that all of her evidence that she's putting in from a forensic standpoint might not tell you the exact thing that happened. And in fact, when she brought those forensics in and she questioned them, they could not basically state certainly that the trajectory was from that back seat. And here's the reason why. We heard on cross-examination, and I mentioned this before, that we don't know so many of the variables. We don't know how high or how tall the individual was. We don't know where he or she was sitting. We don't know any of the information which could actually give us the trajectory of those bullets. And so they actually had to admit on the stand during cross-examination that essentially it was a guesstimate. So I think it's a very difficult issue. I think that that's a weakness in the prosecution's case, and I think if they can't definitively state how those bullets were shot from that back seat, it's really going to be very difficult to put Melly in the box. And that's what they've done right now. I think Bob is absolutely right. They've said, look, Melly was the one with the gun. Melly was the one who shot. He was in the back. You have that, gunshot on close range. And so for those reasons, they decided that he was the one who was the shooter. But it's not that definitive, at least not in my mind, and I think in the minds of those jurors as well.
Mm-hmm. Well, it'll be interesting. Terri, I want to see what you say later in the day about how this jury looks as they're listening to the testimony. I know it's hard to read them, but sometimes they're kind of expressive and you can tell what they're thinking. But we still have a long way to go. And we are going to take a quick break. So stay with us and keep your questions coming to us on YouTube, Instagram, TikTok, Twitter, Facebook, and we'll get to as many of them as we can. I'm Anjanette Levy, and you're watching Law and Crime. We'll be right back.